Thank you. So an interesting discussion in the emerging markets context is, I think, that ultimately not only should we see that the antitrust regime in general has to exclude policy objectives, goals that don't belong to this field, such as the protection of the small enterprises just because they're small, or such as protection of competitors but not competition, such as inflation policing and fighting with increases in price, such as protection of the environment or general public good in the form of health and all. These are very valid policy objectives, but they don't belong to the competition law field. Another thing that we need to be vigilant, especially in the emerging markets now, is the impact of a particular development in a policy objective that actually does belong to competition law, which is fostering of innovation. Now, dynamic efficiencies obviously are a part of the equilibrium because distributive efficiencies and cost efficiencies are an important source of economic efficiency in general, and therefore the chance to maximize welfare. The same happens to be true for innovative efficiencies, dynamic efficiencies even more so. It's probably correct to say that dynamic efficiencies are the biggest engine of welfare maximization. However, the way this is being pursued in the more mature competition law regimes, unfortunately, is leading to a result in the emerging markets that the emerging markets may be paying lip service to innovative efficiencies and they may be actually engaging in perverse enforcement under the banner of protecting innovation. If I were to, let's test this, if I were to tell you that as of this morning, the Mexican Competition Authority and the Turkish Competition Authority and the South African Competition Authority and the Brazilian Competition Authority have all decided that they're going to use a significant impediment to effective competition test from now on all mergers, and that they're going to engage in innovation analyses in mergers that lend themselves to this analysis. A lot of you would be taken aback, and a lot of you would be thinking, well, one, these are not jurisdictions that are originating that innovation, so this is bothering me a little bit because they shouldn't be taking the lead in the sense that there could be an erroneous analysis here. And two, do they have the economic analysis tools and equipment to deal with this issue? Now, the problem is that it seems the European Union does not have the appetite to engage in the same factual economic analysis that is required for these kinds of analysis either. It seems they're just throwing at us literature and theory. I'm not belittling literature and theory, they're very important, but untested literature and untested theory, and they are going after a theory of harm very easily with leaps of faith. Now, when that's happening in the European Union, you can assume that the inspirations of that in the emerging markets can be very dangerous, in the sense that then a lot of agencies may also engage in untested theories of innovation, especially with the same types of reflexes that we see with the more mature antitrust agencies. The reflex that they actually do use the traditional reflexes, i.e. market power issues, concentration ratios, what does this do to distributive efficiency in the form of price increases, and then when they're ticked off by it, the secondary supportive line of argumentation against the transaction would be innovation issues. So innovation issues are never really evaluated within their own right, but they are actually supportive troops of raising problems. When that's the case, we may start seeing emerging markets, and we're certainly seeing it in a couple of those. We may see emerging market competition authorities paying lip service to innovation at times, or actually making points on innovation that are going to make their way into the precedents. Nevertheless, unfortunately, whenever it is time to hear innovation defenses as such, they would be deaf to it. So when it is time to raise a concern, and when it is time to make it an issue, innovation would then become visible to the antitrust agencies. But whenever it is a defense in favor of a transaction, when it's presented as a countervailing factor of traditional competition law worries, then it may fall on deaf ears. The same may happen on the use of standards of proof as well, in the sense that it seems right now the standards of proof that are used with the more mature agencies in the world are standards of proof that don't really allow for the budding discovery phase innovation to be demonstrated to the agencies. The agencies almost are comfortable with the notion that they don't exist. Whereas we all know that without budding innovation and discovery phase innovation, all of this innovation that is happening more and more cannot possibly happen. However, we're constantly turning a blind eye on the existence of these. This is quite concerning, especially when you see the way the world is changing. In 1996, Richard Rapp in Antitrust Law Journal has said, innovation is intangible, uncertain, unmeasurable, and often even unobservable, except in retrospect. It is unfortunate that some 25 years almost have passed, and this sentence could have been written just yesterday, and we wouldn't be criticizing it, so we haven't demystified innovation at all. On the other hand, when this sentence was written, there were 16 million users of internet in total in the world. And today, when there's a Facebook disaster, it leads to 90 million people being impacted, and there are 4 billion users of the internet. And the entire market has changed entirely into digitalization and all that. So I contend, therefore, that we keep on using the same hammer, but the nail has changed so dramatically that we're now at the crossroads of either recognizing that we need to engage in factual economic analysis that is warranted by the given case at hand, which is a technology that will exclude emerging markets authorities for a while and for good, or we will start paying lip service to innovation, and we will start hijacking the concept for traditional reflexes' sake, in which case the emerging markets will also jump on the bandwagon, and it's going to be very difficult to then sanitize the process.
Okay, so thanks to everyone on the panel. A lot of intriguing questions to me. So I want to start actually between first and the last. So I was intrigued when Tembi said, well, of course, we can't block any of these mergers. These are all going to be allowed. And I thought, well, from the point of view of global consumer welfare, if no one can block them, but they should be blocked, something's wrong. And then I'll take Ionnas's descriptive notion of a bargaining process and then put this hypothetical to the panel. So suppose the 5 BRICS countries decided to merge their merger review, all right? So they decided that for very large transactions where no one apparently has enough power to stop them, they agree to have a single merger authority which would review the transaction. And they'd have you can figure out how they would do it. So would that solve a lot of the problems that we see here? Would that be a good idea? Is this just in these huge mergers with multinational corporations, the bargaining power is distorted, sort of abusive dominance. vis-a-vis the agencies. So maybe they should merge. So I'll, any reactions from the panelists as to whether that's a good idea?
And I've done about 300 merger control filings, and Bayer Monsanto is a file of mine, Dow DuPont is, ABI Sabmiller is, ChemChina, Syngenta, Luxottica, Essilor, all of these, which means I may be a bit biased. But I don't believe that it would be a correct statement to say that the antitrust agencies are overly permissive. Maybe in the well-developed antitrust agencies we could discuss this, but in terms of what Tembi has said at the very beginning, we don't say no. I don't believe that that's exactly the case, at least in my 20 years of experience as an attorney. That's not how I have seen it. How I see it is the antitrust agencies know that the parties don't say no. So investment bankers are a particular interesting breed of human beings. They don't know how to say no. So these deal-making people, they try to make the deal. They will make the deal. And when you have that kind of an environment, even if you were to see certain remedies that are striking the parties in the heart, and they're honestly in teleconferences to us are saying this is insane, this is outrageous, they will still find a way of taking that oomph and still proceeding with the transaction. The fact that there has not been a strike down rejection kind of a decision, therefore does not necessarily mean that the merger control analysis does not have teeth. It's a game of remedification now, and there are a lot of remedies flying around. When the R&D line and the pesticide business was divested in Dow DuPont, it wasn't that the CEOs deciding about it wanted us to give them summaries of the 915-pager decision by the European Commission. It was a very quick question of what do we need to do to make this deal still happen. So we might be a bit, looking at it from not exactly this right direction when we make rejections the proxy of whether merger control is working or not. Rejections are something to be avoided. Ultimately, rejections are not a good thing. And if two parties of a transaction came together and wanted to do a deal, there has to be an inherent assumption of some form of efficiencies coming about from those transactions. I'm not saying there has to be a deference to it all the time. All I'm saying is a rejection should be a last resort. Therefore, I think I'd say that, going back to the hypothetical, even if the BRICS antitrust agencies were to come together, they would be a better antitrust agency only to the extent they are communicating better in terms of issue spotting, which is actually a need in the world right now. So it does frequently happen that an antitrust agency gives a phase 1 clearance, although there's quite a bit of concentration going on in that jurisdiction, and then another antitrust agency raises a flag and makes it fall into a phase 2. The first antitrust agency feels, ooh, I should have done this as well. Actually, I have cut them too much slack. An even worse HHI index is seen in my jurisdiction. Now I'm going to be seen as not doing my homework and all that. So when taking issues and when raising a flag, I think more communication would make life better also for the private practitioners. And the same with remedification as well. It would avoid redundant remedies being produced into different files. It would mean that we could go about with presenting one set of remedies to one jurisdiction, and all the affected other jurisdictions can do their own analysis and wouldn't want the same remedy to be produced into their files and all that. But long story short, I feel that the merger control analysis may have its flaws, but ultimately whether it works is not a function of whether there are enough rejections around. Especially South Africa, to my left, you have the commissioner. is a jurisdiction where you do see that a lot of players are getting out of their way to accommodate the agency. There are employment requirements that are articulated, requirements that are not particularly known as competition law per se related matters. So there are, public good arguments that are happening in the review of some of the agencies, and I think they are also accommodating these requests because they feel they have to have these transactions go through. So it's a game of whatever one can bite and chew rather than what one can reject. And my fear is that if there were to be the power to actually reject a global transaction, it wouldn't be used to globally reject the transaction. It would be used to bite something more and chew more.
What do you think are important and concerning implications of increasing mega mergers on inclusive and sustainable growth and public interest, as you define it, at the global level? And how do you think we should manage those implications?
All right.
Okay, so that's 1 hour. So it's a great question, though. It really goes to the heart of what we're talking about. There was one person back there. I can't see from.
I'm not an investment banker now, but I was an investment banker.
Your confessions of a
And
former.
one of the things that you haven't raised, which struck me, is that you assume that these mergers are uncontested. And then certainly in a contested merger, you would have investment bankers on opposite sides who might try to use the competition or other kinds of regulations in order to have their opponent knocked out. So I wouldn't, so you would have experts coming in on both sides, or maybe even more than one if you have even maybe three, if it's a particularly desirable piece of property or a particularly desirable merger. You might have people you might have even 3 or 4 situations. And some of these can be very big. If we look at, for instance, Comcast trying to acquire Disney, competing to acquire Fox News, and also the interest in Sky. I mean, that was, and clearly they were using UK competition policies and regulations in order to favor, in that particular case, Comcast. So I think that you can't just assume that it's straightforward, but how do you handle situations which are highly contested?
So complexifying the bargaining game. So reactions to either or both sustainable growth issues and how this plays in, and the complexity of contested offers. Anybody?
If you want, I can take on the.
Okay, yeah, sure, yeah.
So it is true that we see in private practice quite a bit the landscape changing according to the regulatory landscape changing, so the transactional and the negotiation landscape changing according to the regulatory landscape changing, and especially when there's a signaling of a phase 2 investigation or that things are becoming more complex, it is true that parties start flexing their muscle, especially if there's a hell or high water kind of a clause in the share purchase agreement. And that is very interesting also for the competition law practitioner, because then you start getting mandates that ask you questions of, did the case handler say, I want remedies or not? No, well, that's my interpretation of what they want, but then, no. If they have not said we want remedies, at this point, we can't offer it. Okay, then, they did not explicitly say, but just so that culturally, they would never say that in Turkey. Okay, so could you give us a legal opinion that says culturally they would never say this? And, so it gets very complex and it's very interesting as well. On the point of inclusive and sustainable growth, in mega mergers, I think also it has to do with who the merging parties are and what their true DNA and corporate culture is. Because if the country that you're talking about is a country that has issues with corruption, issues with overall compliance matters, freedom of speech matters and all, then a company with a backbone about these kinds of things engaging in mega mergers in your country cannot be entirely a bad thing.